how letting agents should prepare for lettings legislation. Today I'm joined by Des Taylor, who is the boss man of landlord licensing and defence. Des, you said to me before you switched the cameras on, letting agents should put some money aside for the enforcement, defence and dispute resolution with regard to the Renters' Right Bill. Why is that? Talk to me.
Because the Renters' Rights Bill is going to bring in so much more enforcement for things that currently require the local housing authority to prosecute you at the magistrates court, you need to be ready, because they're going to send you out notices of intention. They're going to send you out notices asking you to fill in documentation and sign it, which essentially could be self-incrimination. So you need to put some money aside to, one, have consultations with firms that will be able to assist you in that legally and professionally and tell you what you should and shouldn't answer, because not answering could get you in as much trouble as answering. You don't want to say something that you're trying to defend yourself while also at the same time admitting new offences that may not be already on the table. So it's very important to do that. And with tenants now we're seeing so many more tenants going to no-win, no-fee lawyers for disrepair claims, deposit protection claims. You need to be able to employ somebody who's successful at resolving those things without the need to going into legal proceedings. So you're going to need to have money for dispute resolution. I think it's the fastest and easiest way to deal with it.
You really think it's that bad?
Yes.
I mean, there's plenty of letting agents that have had people knock on their door with regard to the deposit stuff. I still think there's plenty more on that to go, isn't there?
Absolutely. And currently what we see with a letting agent or a landlord, but more letting agents in particular cities, there's one offence and then they work their way through the properties they know that you may be managing, or you've had to provide a list as part of their processes of those properties, and they work through property after property after property.
Do you legally have to give them that list?
Yes, I'm afraid you do. Under Section 235 or Section 16 of the Local Government and Miscellaneous Provisions Act, it's an offence not to provide the information or to manipulate the information. So you have to.
I mean, are you still coming across letting agents who don't even bother registering deposits then?
Yes, quite common. Yeah.
I mean, this was how many years ago?
2000, the Deregulation Act was 2015, but it was 2007, I think, before. So yes, there are people who are still getting it wrong and taking first month, last month, and giving license to occupy agreements and all sorts.
And this Renters' Right Bill is going to be even worse.
It's going to be even worse, because all of these things are going to be at the scrutiny of the local housing authority, who will be able to impose financial penalties rather than prosecute you in the magistrates court.
And because it's easier to get a conviction and they get to keep the money, you reckon they're going to be going after it?
Yes, because people will do like they did with parking and like they've done with speeding. Is it worth it? So they have an enforcement policy. The fines are set out at certain levels, and if you meet that criteria, they're going to fine you. And as a letting agent, you're highly experienced. So in London, in the London Borough of Camden, for a letting agent, the general minimum fine is £20,000.
And there's agents getting fined this all the time?
Every single day.
Big names, small names, and
big names and small names. And I've watched some of the big names defend their position with lawyers who are generalists, and quite frankly, the defences they put forward in the bundles, I'm quite surprised that they even are writing them. So it really is that specialist.
I mean, obviously you're going to say that because that's the job you do. You help letting agents with enforcement. What are the sort of things that they should be doing now to prepare for the Renters' Right Bill?
So right now they should be, first of all, making sure that all the current tenancies they've got were initiated properly and everything was done correctly with regard to how they gave the prescribed information, how they've done the deposit. They need to understand that the properties have been inspected and are up to the standard they need to. So they're going to need to employ people to do that. And they need to make sure that if they're thinking about serving any sort of notice to somebody, that everything's in place to do that correctly, because everything's going to change once this comes in.
Well, especially when Section 21's going. If it goes Section 8, it's going to be in front of a lawyer, a judge, isn't it?
Absolutely. And I think the bit that many are going to miss out on is when you rent a property as a buy-to-let, and you let it to, say, a 2-bed or a 3-bedroom property to, say, 2 friends, it doesn't come under any legislation if there's no selective licensing. But if they bring in somebody else, so one of the friends meets somebody and they decide to move in, you've created a HMO. And then HMO management regulations kick in. And then if there's additional licensing in the area, there's licensing. And this is where a lot of good agents are getting caught out, because the need to do inspections needs to be now every quarter, because you need to know what's changing in the property and make sure doing it every 6 months just isn't enough.
If you were doing an inspection every quarter, you know, the new move-in boyfriend you might not see, but is that going to help your cause if you were put in front of a judge?
Yes, it is, because one of the things I've been in front of many judges and for and on behalf of landlords, and quite often I've asked the question, because the landlord doesn't want to accept what's being said, could you please explain for the benefit of the landlord the situation? And one of the key things that one of the judges was very clear on is, if your management records, that's both photographic and written, can evidence that you are truly managing, then you may well have a reasonable excuse defence, or the punishment that we're going to give you may not end up in a fine. So it's really, really important to demonstrate good management, and that's going to come down to technology, and it's going to come down to record keeping and being absolutely
So just going
organised.
around doing an inspection and I'm walking around saying everything's okay. So
Not good.
is that a huge tip here? Is take photographs?
Take photographs and make notes. And there are lots of apps out there today that
Yeah, well,
you
you
can
can
do basic
dictate
stuff.
it and it puts it straight in.
Yeah, but there are inventory apps out there. There are plenty of them, and technology's there. Everybody's got a phone or tablet in their hand. You can take those pictures, you can dictate it, you can give it to a VA to sort it out afterwards and make it all perfect and get it all presentable. But there are apps there that will do that already with AI in them. So that's the most important. If you're going to do this work, you need to make sure that you're selling a service that warrants it, because if you just sell rent collection or let only, but you initiated that tenancy, you are going to be on the hook for the things that are wrong, because you're part of that tenancy initiation. Camden in London, 6 or 7 years ago, was very successful at holding a letting agent responsible for licensing and HMO management offences, because they'd initiated the tenancy and received the initial rent.
It sounds like rent collections on the way out then.
I think it should have been on the way out a long time ago.
What about tenant find?
Tenant find, again, you've created it. If you create the tenancy, the local housing authority will investigate and want to know how that came about. And quite often on a tenant find, they're creating the tenancy.
So you're telling me tenant find letting agents could come a cropper even though they're just tenant find or rent collection?
Yes, because the local housing authority will do an investigation, because as they investigate the landlord, the greatest witness they have is the tenant. So one of the questions they ask the tenant is, how did you come to find this property? Where was it advertised? What was it advertised for? What was the rent you were asked to pay, etc. All of the things that you can see as part of the Renters' Rights Bill coming in.
And you're telling me that if the local authority found you guilty, they don't need to take you to a judge. You don't have to go to a judge, or you do have to go to a judge?
So you don't have to go to a judge. The local housing authority does the investigation.
Yes.
Once they do the investigation, then they decide whether you're guilty of an offence or not. Now, on a tenant find, they've got to have the evidence at a criminal level, which is beyond reasonable doubt. Are they going to find it? They're probably not just on a tenant find. If you created the tenancy, they're probably going to say that, yes, you are. And then they've got to decide, is it in the public interest, and is it likely they would get a conviction? If they are, then they will issue a notice of intention to impose a financial penalty, at which stage you then seek advice and do a representation. My advice is, the moment you hear from the council, seek professional advice from the few firms that actually do understand this law, and then get that advice from them and follow what they say. Either get them to represent you, which is, I hate to say, probably much better. In the same way as when you go for a job and you negotiate yourself, you don't tend to get as good a deal as when a recruiting agent does it for you. Well, in the same way with legal matters, if you've got somebody dealing with the council, you're probably going to get a better representation, because the rebuttals are going to be faster, quicker and better understood.
Thank you for your time today, Des.